I want you to, just for a second, picture something. You're a government doctor, a civil surgeon. You've put in 30, maybe 35 years. You've seen it all, right? The endless patient queues, the red tape, the emergencies. You've done the work.
You're at the finish line.
Exactly.
Yeah.
You are literally days away from retirement. You can smell it, the pension's sorted, maybe you've even booked a little trip.
Yeah, you've earned that peace and quiet.
And then, 48 hours before you're out the door, a courier shows up. It is not a goodbye card, it's a suspension order, a full departmental inquiry. And the crazy part is, it's not for malpractice or theft. It's because, like, 5 years ago, some local politician wanted to favor something illegal and you said no.
And you can guess that politician has probably moved up in the world since then.
Oh, he's the chief minister now.
Yeah.
And he's decided to use the entire power of the state to freeze your retirement and ruin your name just to settle an old score.
It sounds like a complete nightmare. But, we have to be clear. This isn't just some hypothetical story we made up.
Yeah.
This is a real case.
Yeah.
And it's one of many we're looking at today.
Right. So for this deep dive, we've got a whole stack of these legal case studies. And honestly, some of them are just terrifying. We're talking vindictive ministers. We're talking about rules that get women fired for getting pregnant.
Students expelled without a single question. It's a real catalog of power being misused.
Yeah.
But we're not just here to, tell scary stories. We're here to talk about what stops this from happening. We're here to talk about the invisible shield.
The invisible shield. I like that. So that's our theme.
I think so, yeah. The government, the state, it's this massive entity, right? It can tax you, it can fire you, regulate your whole life.
Yeah.
And administrative law.
Yeah.
That's basically the only thing that stands in the way. It's the rule book that tells the government, look, you have power, but you still have to play fair.
So it's the instruction manual for the little guy versus the system.
Fundamentally, yes. It's this constant tension between authority, which is the government's need to get things done, and liberty, which is, your right not to get steamrolled by it all. And the sources we have today are just fascinating because they show exactly where the courts draw that line.
Well, let's start with that doctor then, that nightmare scenario. This gets into a legal idea called malice in fact.
Malice in fact, exactly. And it comes from a huge case. But to get it, we need to define a word you'll see a lot in law. Malefied.
Malefied. Sounds a bit ominous. Latin, I'm guessing.
It is. It just means bad faith. See,
Yeah.
Normally the law looks what happened, was the form filled out right. But with malefied, the question is why it happened. So with that civil surgeon, on paper, the government can suspend an employee. They have that power.
So if you just looked at the order, it would seem totally legit.
Totally. The chief minister had the authority. But when the Supreme Court started digging, they found the whole reason for it was rotten. The entire inquiry was started, and I'm quoting here, to wreak personal vengeance.
Just because the doctor didn't play ball years ago.
Exactly that. And the court said, absolutely not. Even if you have the power, if you use it for a personal grudge, the action is void. That's malice in fact.
So the power is for the public good, not your private hit list. It doesn't matter if you ticked all the boxes if the whole reason you're doing it is corrupt.
The root is poisoned, so the food is poisoned. Simple as that. You can't use the state as your own personal weapon.
We have another case that's almost, I don't know, even pettier. The bus routes case.
Oh yeah, that's a classic. A perfect example of weaponizing public policy.
So set this up for us. The state transport company decides it's going to nationalize bus routes. Basically, boot out the private guys and run them as government buses.
Which, on its own, is fine. It's a normal government policy. They might do it for efficiency, for service, whatever. It happens.
Sure, but here's the thing. They didn't nationalize all the routes. They sort of handpicked them. And whose routes did they just happen to pick?
You'll be shocked to learn it was the routes belonging to the chief minister's political rivals.
I mean, it's just so blatant, isn't it? Oh, you ran against me in the election. That's a nice little business you've got there. Be a shame if something happened to it.
And that's the Malafide argument all over again. The court just said, nope. This is a clear misuse of discretion. You can't design a public policy just to hurt your enemies.
Yeah.
And because the motive was so clearly ill will, the whole thing got thrown out.
It's good to know that the courts can actually look behind the paperwork. But, okay, let's shift gears. Because sometimes it's not about malice, right? It's not personal revenge. Sometimes the rules themselves are just, well, they're just wrong.
Or, to use the legal term, arbitrary.
Arbitrary. Right, and this brings us to this idea of delegated legislation. Can you break that down for us, like the simple version?
but they can't write every single tiny rule for, say, aviation or mining. They don't have the time or the specific knowledge, so they pass an act and they delegate the power to make the detailed rules to an authority like the Air India Board.
So Parliament says, go run an airline, and the airline's board writes the actual employee handbook.
Exactly. But, and this is the most important part, the rules they write, the delegated legislation, cannot violate the Constitution. The child can't be more powerful than the parent.
Which brings us to this Air India case. I mean, I was reading this and I had to check the year. The rule is just, it's from another planet.
It is genuinely shocking. So Air India had a service rule. It said an air hostess could be terminated fired upon her first pregnancy.
Just stop and think about that. You work hard, you get this great job, and then the moment you decide to start a family, you're out.
It forces a woman into an impossible choice between a career and a family. And the Supreme Court just took one look at it and threw it out. They called it arbitrary and abhorrent to the notions of a civilized society.
And the legal reason was what, Article 14?
Yeah, the right to equality.
Yeah.
Was blatant discrimination based on sex. You can't make a normal biological process, one that's fundamental to being a woman, grounds for losing your job. It's an unreasonable classification.
Okay, but I want to push on that word, classification, because there's this other case in our notes about taxi tariffs that seems to say classification is okay.
Ah, yes, the Harnam Singh case. This is where it gets a little more subtle.
Yeah, so in Bengal, the rule was small taxis pay a lower tariff, big taxis pay a higher one. Isn't that also discrimination? You're treating two taxi drivers differently.
It's differentiation, yes. But the law asks if it's unreasonable discrimination. And the rule is you can treat different groups differently, but you need a good reason for it. It's called the test of reasonable classification.
And what's the good reason there?
It's just basic physics and economics, what lawyers would call a rational nexus. A bigger car has a bigger engine, it burns more fuel, takes up more space, puts more wear and tear on the road, and probably charges a higher fare. So it's perfectly logical to tax it more.
I see. So there's no logical connection between being pregnant and being a bad flight attendant.
None whatsoever.
But there is a direct connection between having a big engine and using more public resources.
You've got it. That's the test. Does the rule actually make sense for the goal it's trying to achieve? For Air India, no. For the taxis, yes.
There's one other one here on minimum wages. The Edward Mills case. This felt a bit like the company was just complaining for the sake of it.
It does have that feel, a little bit. The government added their industry to the list of jobs that had to pay a minimum wage. The company basically argued, hey, you can't just add us, it's arbitrary, there's no process.
And the court's response?
The court basically said, read the main law. The whole point of the Minimum Wages Act is to stop workers from being exploited. So if the government sees exploitation happening, they have the power to step in. That's not arbitrary. That's them doing their job. You don't get to complain just because you now have to pay people fairly.
Okay, so we've got bad intentions or malice and bad rules or arbitrariness. What about bad procedure?
Ah, now this is my favorite part. Natural justice.
The right to be heard.
That's the one. There's a Latin phrase for this too, of course. Audi alterum partem.
Okay, break that down for us. Audi alterum partem.
It literally means listen to the other side.
Yeah.
It's one of the most fundamental principles we have. You cannot punish someone, no matter what they've done, without at least giving them a chance to tell their story.
And we have a case here about a student. This poor kid.
Yeah, it's a tough one. He takes an exam, and the board thinks he cheated. Maybe his answers looked a bit too similar to the person next to him, so they cancel his result and they ban him for a year.
And they never even talk to him.
No notice, no hearing, no chance to say, hey, wait a minute, just boom, decision made.
And that's not allowed.
No. The court said that even though a school board isn't a courtroom, when it makes a decision that big punishing a student, affecting their whole future, it's acting in a quasi-judicial capacity.
Quasi-judicial, that's a key phrase.
It means like a judge.
Yep.
If you're going to act like a judge, you have to follow the basic rules of a judge. And rule number one is you have to hear both sides.
Because maybe he had an explanation. Maybe the other guy copied from him.
Who knows? But you can't find out if you don't ask. And the law says you have to ask.
Okay, look, I'm with you on the cheating thing. That feels right. But we've got another case here. Problem 15, the stabbing incident. And I have to say, this one really tests my commitment to the principle.
I knew you were going to bring this one up. It's the ultimate stress test for natural justice.
So a student is debarred, banned from campus because a criminal case is pending against him for stabbing another student.
Very serious. A clear danger to other people on campus.
Right. So my gut reaction as a parent or just a normal person is get him out of there. Safety first. Why on earth do we need to have a hearing? Someone got stabbed.
And that's a totally understandable reaction. The guilt is obvious, so let's skip the formalities. But that's the thing about this invisible shield. It doesn't work if we only apply it when it's easy or convenient.
So the order to ban him from campus, that was invalid.
It was, because the college stripped him of his fundamental right to an education without following the rules of natural justice.
Even though he stabbed someone.
Well, hang on. Did he? What if he was acting in self-defense? What if it was a case of mistaken identity? What if the whole story was made up by a rival to get him kicked out? If you don't have a hearing, you're just acting on an accusation. The court isn't saying, let dangerous people run wild. It's saying, before you take away someone's rights, you must hear their side.
It's a really high bar. It forces the system to slow down, even when everything is screaming for a quick decision.
It does. It says that fairness is more important than efficiency. Because if you let the principal expel a student without a hearing because it's obvious, you're opening the door for them to expel another student later just because it's convenient.
That brings up another interesting one here. The case about blind obedience. A tax officer.
Ah, yes, the classic I was just following orders defense.
Yeah, right. So a tax officer is looking at a citizen's file, and he knows, he can see, this person doesn't actually owe any tax. It's a mistake.
He's used his judgment, his expertise, and the liability is zero.
But then his boss comes in and says, I don't care what you think. Assess the tax. Send him the bill.
And the junior officer just goes along with it, writes up the order.
Is that a valid order? I mean, in most jobs, you have to do what your boss says, don't you?
In a normal job? Maybe. But not in administrative law. The court said the order was invalid. Because when an officer is given a power by law, the power to tax, they have to use their own mind. You can't just surrender your judgment to your superior.
So if you know something is wrong or illegal, you actually have a duty to not do it.
You have a duty to apply your own mind, yes. Following orders is not a defense for violating someone's rights. It puts the responsibility right back on the person making the decision. It stops the system from becoming a machine where everyone just points up the chain of command.
I like that. It protects the citizen.
It does.
Okay, let's move to our last big area, money and property. When the government screws up, can they just say, oops, sorry, sovereign immunity, we can't be sued?
Well, for a very long time, that was basically the case. The old English idea was, the king can do no wrong. The government made the laws, so it couldn't really break them.
But we don't have a king.
And that is exactly what the Indian courts have made very, very clear. A great example is the confiscated goods case.
This one is just a business owner's worst nightmare. The government seizes your goods. Maybe it's fertilizer or something. Because they think you broke a rule.
Right. They confiscate it. Then, maybe years go by, and a court finally says, you know what, that seizure was illegal. The business owner was right all along. Give him his stuff back.
But by that point, the fertilizer has been ruined by rain, or it was sold, or maybe it was just stolen from the government warehouse.
Exactly. So the owner sues for the value of the goods. And the government tries to argue, hey, we have sovereign immunity. Our officers were doing their job. We're not liable for their negligence.
And did that argument work?
Not a chance. The Supreme Court basically said sovereign immunity is a relic of the past. When the state gets involved in commercial activities and messes with someone's property, it's liable for damages just like anyone else.
If you break it, you buy it, even if you're the government.
Especially if you're the government. Because you have the immense power to take property in the first place, you have an even greater responsibility to take care of it.
That's reassuring.
Yep.
But there's a huge catch here, isn't there? We have to talk about the informal contract case. This is a big warning sign.
Yes. Karamchi Jetapai. This is something everyone who does business with the government needs to hear.
So this farmer, he needs canal water for his crops. He sends letters to the government department. They write back. They go back and forth. They agree on everything. It's all there in writing.
Looks like a contract, right? Offer, acceptance?
Totally. But then the government messes up the water supply, and he sues them. And their defense is, what contract? There is no contract.
And incredibly, under the law, they were right.
How is that fair? They had an agreement. It was in the letters.
I know, but the law is incredibly strict here. Article 299 of the Constitution is very specific. It says any contract with the state has to be in a formal, written deed made in the name of the president or the governor.
So a bunch of letters, even from the head of the department, isn't good enough.
Not even close. The idea is to protect public money from being promised away by any random official. But the lesson for all of us is simple. If you're dealing with the government, don't rely on a handshake or an email chain. Get the formal, signed deed, or you have nothing.
Wow, that's a brutal lesson to learn. Okay, one final case, and this one is a bit of a curveball. The forgetful judge.
Dimes vs. Grant Junction Canal. This one really gets into the nuances of bias.
So, a top judge, the Lord Chancellor, he decides a case in favor of a canal company.
Pretty standard stuff so far.
But then it comes out that the judge himself owns a bunch of shares in that exact same company.
Which is a huge red flag. That's what we call pecuniary bias. Obviously, if you own stock, you want the company to win.
So the losing side appeals, saying the whole thing should be thrown out, the judge was biased, seems like a slam dunk.
And yet,
Yeah.
the decision was upheld. It stood.
How? That seems to fly in the face of everything we've been talking about.
The key word was inadvertence. The investigation found that the judge had genuinely completely forgotten he owned those shares. It was an honest mistake, not a corrupt plan.
You can just forget you own stock.
Well, maybe it was part of a huge portfolio managed by someone else. Who knows? But the point the law made was about intent. The invisible shield is there to protect us from malice, from bad faith. But it can make allowances for honest human error. Because it wasn't intentional, it didn't count as bias in a way that would invalidate the whole case.
That's surprisingly forgiving. The law can tell the difference between a villain and just someone who's a bit forgetful.
In a way, yes.
Hmm.
It shows that it's not just a rigid set of rules. It tries to be practical.
So let's try and wrap this all up. We have covered a lot of ground.
We certainly have.
We've seen the government can't be vindictive, right? No personal grudges. It can't make arbitrary rules like firing pregnant women. It absolutely has to listen to your side of the story before punishing you.
Even if the accusation is incredibly serious?
And it has to pay for its mistakes when it damages your property, as long as you got the contract right in the first place.
That's the big asterisk, yes.
It really is a shield.
It is. It's the answer to that age-old question, who watches the watchers? Administrative law is what ensures power is used legally, reasonably, and fairly. It's what makes the state a responsible party, not just a ruler.
It makes sure authority doesn't completely crush liberty.
Precisely. But I want to leave you with one last thing to think about.
Let's hear it.
We talked about how natural justice, the right to a hearing, applies to quasi-judicial acts, things that are like court cases. But the trend, if you look at the cases now, is that the courts are blurring that line.
What do you mean?
They're starting to apply these principles of fairness and the right to be heard even to what we used to call pure administrative functions, things like getting a driver's license or a passport.
So fairness is just becoming the default setting for literally anything the government does?
It's heading that way. But here's the big question that raises. If every single administrative decision, every permit, every ticket requires a full court-like hearing, does the whole system just grind to a halt?
Right. If you have to hold a mini trial every time you reject a building permit, nothing would ever get built.
So is efficiency the enemy of fairness?
Mm-hmm.
Or is a bit of that inefficiency, a bit of that slowness, the price we have to pay to make sure that our liberty is actually protected?
Is the red tape a bug, or is it actually a feature? That's a lot to think about the next time you're stuck in a queue at a government office.
It is.
This has been absolutely fascinating. Thanks so much for breaking all this down for us.
It was my pleasure.
And thank you all for listening. We'll see you on the next Deep Dive.